Hello students, my name is Dr. Jyoti Prakash and I am assistant professor in the Department of Management, School of Management Sciences, Lucknow. Now welcome you all to the video lecture that is based on the topic employee relation and industrial relation. As I told earlier that uh, uh, in one proverb in Hindi that जहाँ चार बर्तन होते हैं वहाँ आवाज़ होती है means as we all know that an organization is basically made of different people or the human resources, and we all are having different background and we all belong to different classes and we all share the different characteristic, different personality, different attitude, different perception. So while working for a common goal, while working in a group or in a team, some disputes or some grievances occurs while performing or while or being a part of a group or while being a part of a team. So, in this video lecture we will focus on the resultant or basically one of the important factor that is somehow related to the concept, that is industrial relation, and one of the relation one of the related factor is industrial disputes. As I told earlier and I told that told you in the previous video too, that while working in a team some conflicts and some disputes arises. So, if disputes arise in the organization, if different dispute arises in the organization, so obviously what are the ways, what are the preventive measures and what are the causes which are responsible for these disputes. In this video lecture we will have a discussion on these aspects related to the disputes and the resolution of the disputes arises in the organization. So, firstly we should understand that what is the meaning of disputes and dispute. So, according to Industrial Dispute Act 1947 section 2K, that industrial disputes mean any dispute or difference between employer and employer, or between employer and workmen, or between workmen or workmen, which is connected with the employment or non-employment or term of employment or with the condition of labor of any person. In totality we can understand about, or we obviously we must have information about this particular topic. What dispute means, somehow there is a disagreement and there is basically a difference between two opinion, and in that case this particular dispute arise. So, somehow if we talk about industrial dispute, so if there is a disagreement, if there is a difference between the opinion between or between the expectation of the employer and the employee, that will obviously result in what, this particular dispute. So, if disputes arises in the organization, what are the forms of, or what are the ways for showing or for doing or for involving in this particular these type of or in this particular dispute in fact. So, these are different ways of disputes, like the first one is strikes, the second one is lockouts, the third one is gherao, and the fourth one is picketing and boycott. So, just understood different forms of industrial disputes, like the strikes. Strikes are basically one of the type of dispute which are initiated by the employee for in case of non-fulfillment of their expectation and their requirement. Lockouts are basically the temporarily, we can say that temporarily closure by the employer, means the strikes are initiated by the employees and lockouts are initiated by the employer, again in the absence of, in the case of non-fulfillment of the expectation. And gherao is somehow we can say that informal enforcement or informal thing done by the employee, means the name itself refers that outside the office in fact, or outside the factory, if you want to harm someone in order to show your dispute or disagreement or your grievances, it is somehow that will result in gherao. And the last one is picketing and boycott, means you are just showing your disagreement or you are showing your unpleasure with while showing some cards, some banners and some written statements to all the parties or all the one who are just associated with the organization. Means this particular form of dispute we have regularly seen, and we are very much seen in our scenario that in outside the office some people are sitting and they are just holding a card or holding a banner or holding a standee in which some statement or some opposition or opposed sentences are written, which are giving or which gives some message to the employer or to the concerned organization about that they are not happy with their practices, and they that is why they are sitting outside their gate, and they are just representing their disagreement, and they are just representing their grievances to that employer or to that organization. So, these are basically the different forms of industrial disputes. The next one is obviously what are the causes of industrial disputes. So, these are basically the 4 causes. The first one is economic factor, the second one is management practices, the fourth one is trade union practices, and the fourth one is legal and political factors. The first one is economic factors. Obviously, in case of inappropriate wages or in case of non-regularity in the payment of wages, and these type of disputes arise. In case of non-giving the incentive factor and non-introduction, it means if the employer or the organization has not introduced this motivating factor named incentive, means obviously we have discussed in the earlier videos that in order to maintain or in order to motivate the employees, the organization has to introduce this motivating factor named incentive, so that they just maintain their work and then maintain their productivity in attainment of the goal of the organization. So, if incentives are not being provided by the employer, that would also result in some sort of dispute and grievance. And benefits working condition means if the organization has not introduced the inducive or the healthy working environment or the healthy working conditions, so obviously that will also result in some sort of dispute in the organization. The next one is management practices, means if the employer or the organization has adopted or not introduces the fair labor practices, means somehow they are considering some of the requirement of some of the employees, and some are not being considered in terms of their expectation, in terms of their requirement. So, if the organization is doing these type of practices, so obviously that will result in the form of dispute. Ineffective supervision means if some of your senior body or some of your we can say that managerial person is exploiting the contribution or the performance of some lower level employees. So, if you are not effectively supervise these things, obviously that will create a problem for your organization or for the functioning of your organization. So, it is also one of the factor. The next one is violation of acceptable norms, means if the employer or the organization has given you a code of conduct, the organization has given you some acceptable norms that should be that should be considered or that should be followed by each and every employee of the organization, and some of the employees are not following that code of conduct and those policies. So, obviously it is a case of violation, and in this case too some sort of disputes arise. The next one is trade union practices. So, the first one is union rivalry, means if there is a rivalry, means in the definition of industrial relation we have understood that there is a need to maintain relationship with different employers available in one industry, so that you just work or you can work in a harmonious way, and there and the conflict may not arise while working or while performing in the industry. So, if some rivalry exists or rivalry available between you and your competitors, so obviously your competitors will do obviously do something which may exploit or which may manipulate the interest or the mind of your employees. So, that will result in some sort of dispute. And the next one is obviously non cooperative approach, means if the union member is not taking care of the welfare of the workers available, and that union member is not cooperative, not understanding the requirement of the workers, obviously that will also result in some sort of disputes. And the next one is legal and political factors, because we have seen in the previous video that there are 3 participants in industrial relation, and one of the player is government. So, obviously legal and political factors related to government means multiplicity of labor law and political intervene, means if government is interfering and government has restricted some sort of, or government has pass or regulated some provisions and some act in order to give compensation, in order to introduce different welfare or safety measures in the organization. So, if the employer has not introduced or not the employer has not amended those things or those regulation into the organization, obviously the employees will create a dispute, or the employees will not work in a harmonious way or in a peaceful way. So, that will result in some sort of dispute. So, these are basically some 4 factors which are responsible for industrial disputes. So, obviously disputes arises. So, these are basically some of the preventive measures. We can say that always prevention is better than cure, means if you problems occur. So, there are so many ways so that you just resolve those problems, but being a human resource manager or being an employer, you just think that the problem or any disputes never arise in your organization, and your activities will go on a smoother basis or will perform in a very easy manner. So, these are basically the preventive measures, means somehow being an employer you can prevent or you can prevent disputes in your organization. So, what are those preventive measures? These are basically the preventive measures, like the trade unions, joint consultation, standing orders, grievance procedures, code of discipline. How these what is the meaning of these preventive measures? The first one is trade unions, means in big industries basically, or in big companies, there in which there are more numbers of workers and more numbers of employees. So, obviously there must be a representative, because being an employer you are not able to hear, or you are not able to meet out each and every member of your organization, each and every worker of your organization. So, you just select out, or basically employer or worker basically select a representative who basically look after the benefit of the workers or the employees. So, you have to just take care of this union member or trade union, and you just call them time to time and understand the problem and understand the expectation of the employees and the workers, and accordingly you just try to fulfill. So, obviously by doing so you are trying to avoid this dispute measures in the dispute factor in your organization. The next one is joint consultation. Joint consultation name itself refers that being a employer, employee and the member of and the trade union member, they just work in a very coordinated way and try to fulfill the expectation of all the parties, so that they just work in a harmony, and they just and that will result in the goal achievement of the goal and objective of the organization. The next one is standing orders, means if some of the problem means by giving orders that whatever the expectation that the employees have, the employer will obviously consider, but it will take some sort of time, but obviously their requirement must be fulfilled. So, it is also one of the measures, means you are just trying to assure your employees that in coming time in future time, or basically in coming time the organization is working on that, and in coming time those requirement or their expectation must be fulfilled by the employer. Grievance procedure means if some sort of dissatisfaction and disagreement arises into the mind or into the behavior of your employees. So, being an employer you just understand or you just introduce a grievance procedure in your organization, that if anybody is having any sort of grievance into the mind, into the heart, into the behavior, so they just they just come forward and they just uh, represent the problem that they have, and accordingly some resolution and some solution can be given to that individual one. And the next one is code of discipline. Uh, Disputes arises, basically it is some sort of a disagreement between the employer and the employee. So, being an employer, if you have framed out or you have developed a code of discipline, and that code of discipline has been communicated to all the worker and to the available workforce, means they are having the picture and they are having the idea about the thing and about the practices or about the element come under discipline, means they have to follow that particular code of conduct. And in case of violating this code of discipline and this code of conduct, obviously the employer will take up corrective action or take against those violation of the code of discipline and the code of conduct. So, you just communicate this thing, being an employee, you just communicate these things to your employees earlier, so that they just your employees just hold an idea that if they may be involved in that type of violation, they will be punished or they will be given, and they may be basically punished for that particular violation. So, these are basically some of the preventive measures. And if after adopting some preventive measures disputes arises, so what is the settlement machinery? So, these are basically the ways through which these disputes, if disputes arises, these are the ways through which disputes can be settled out by the employer. So, what are these ways? The first one is conciliation, the third one is voluntary arbitration, and the third one is compulsory arbitration. It is also called as adjudication. So, just have a look on these elements one by one. So, the first one is conciliation. Conciliation is one of the non-binding procedure, means the suggestion or the order given by the concerned one that does not bind to the concerned parties. That is why it is called non-binding procedure, where impartial third party known as conciliator assist the parties to a dispute in reaching a mutually agreed settlement of dispute. A conciliation officer may be appointed obviously for a specific area or for a specific industry in a specific area, or for one or more specified industry, either permanently or for a limited time period. So, if this type of third party may be is introduced in order to settle out the dispute arises in the organization. So, obviously there must be certain duties and responsibility for the third party assigned or the nominated by the organization. So, what are the duties of conciliation officer? The conciliation officer shall investigate the matter for the purpose of bringing amicable settlement of the dispute, means firstly, if there is a disagreement in general, if there is a disagreement arises between me and my friend. So, firstly what we do? We just talk, we just express, we just understand the expectation or the feeling of others, and accordingly we just provide assistance or provide suggestion to that discussion and agreed by both the parties. In the organization too, firstly there is a talk, there is basically a discussion done between the parties, and if the discussion does not result in us in a common consensus or in a common agreement, so obviously there is a dispute, there will be a dispute arises. So, this particular conciliation officer will be nominated or will be appointed in case of non settlement of the dispute after discussion, after having a discussion or after having a talk. So, the conciliation officer shall investigate the matter for the purpose of bringing amicable settlement of the dispute. If the settlement is arrived at, the conciliation officer shall send a report to the appropriate government or the officer authorized by the appropriate government, and with the memorandum of statement signed by the disputed party, means obviously the employer and the employer or the employers, if they are if they have agreed upon a common sum and they have arrived on a common consensus which somehow resolve the dispute or which somehow resolve the grievance occur. So, that must be submitted to the concerned officer or to the concerned government, and if no such settlement is arrived at, the conciliation officer shall send a report to the appropriate government mentioning the reasons on account of which in his opinion on settlement could not be arrived at. The report shall be submitted within 14 days of commencement of the conciliation proceedings or within such shorter period or may be flexible by the appropriate government. So, these are basically the things come under conciliation. Arbitration is the next one, and arbitration basically is a mechanism in which a dispute is resolved by a impartial third party whose decision is final and binding upon the parties. Means whatever the outcome after having a talk or after giving by the impartial third party, that should be binded, means that should be followed by the parties involved. And there are two types of arbitration. The first one is voluntary arbitration and the second one is compulsory arbitration. If we talk about voluntary arbitration, means somehow it is the name itself refers that whatever the result or whatever the third party has instructed to the involved parties, those third parties are just ready to follow or ready to accept the result announced by the impartial third party, that is voluntary arbitration. But the next one is compulsory arbitration. Compulsory arbitration is also called as adjudication, means if the third party has given order or given order to the involved parties that they have to adopt the instruction or they have to given the result by the third party, but the involved parties are not ready to accept that. In that case, they have to just go through the laws and they have to just go through the court in order to settle the disputes or in order to settle the disagreement arised. So, the ultimate remedy is obviously if you are going to a court, whatever the decision given by the court, you are bound to follow that, and they means it is the last one through which you can just solve out the dispute factor. So, the ultimate, that is why it is called the ultimate remedy. So, the ultimate remedy for the settlement of an industrial dispute is its reference to adjudication by labor court or tribunal when it is happened when the conciliation machinery fails to bring out a settlement. And adjudication consists of settling disputes through intervention by a third party appointed by the government. The law provides the adjudication to be conducted by a labor court, industrial tribunal or national tribunal. Means somehow in totality we can understood the concept of adjudication, that obviously in this particular settlement machinery there is an involvement of a third party that has been appointed by obviously the government, and whatever the decision given by this particular third party, means this third party is obviously somehow related to some person related to the court or the decision of the court, either industrial tribunal or national tribunal, means whatever they are giving decision regarding this resolving the dispute, all the involved parties of that particular disputes, they must or they have to follow the instruction or follow the order what the court has given to the involved parties. So, in totality we can say that adjudication is what the ultimate remedy for settlement of an industrial dispute. So, just have a look on the available machinery. Like the first one is conciliation, means somehow it is also in all the ways, in all the settlement machinery there is involvement of a third party. And the first one is there is a non-binding, means they the third party has given instruction or given order, both parties even may agree or may not agree. The second one is arbitration, means they are they have to follow the order, means either voluntarily or involuntarily, means if you are not ready to with the decision of the third party, you just go to this particular remedy, that is adjudication, means there is involvement of a court and the government, and whatever the decision they are giving to the involved parties, all the involved parties are just bound to follow that. So, these are basically some of the references of the books which gives you more concept related to the particular topic. If you want to get more information, go through these books. I hope you will like this particular video. Thank you, students.